Welcome. I'm Rachel King, and I am joined today by Jay Wilgus, and we will tell you a bit more about ourselves in just a moment. But we just want to start off by saying thank you so much for allowing us this space to be part of the Summit series. Thank you to Sylvia at It's On Us and Kenura and Rape on Campus. This has been a great series. All of the sessions that have been available so far have been really excellent, and we're thrilled to be a part of it. So as you know, this particular session is about restorative justice and gender-based violence. So we thought a good place to start would be to tell you a little bit about ourselves and kind of how we came to this work around restorative justice and a little bit about our backgrounds. So do you want to just say hello first to introduce yourself?
Sure. Hello, everybody. My name is Jay Wilgus. Happy to be with you today. And as Rachel said, thank the organizers for putting this together and such an exciting series. So we're excited to be with you today. Tell you a little bit more about myself in a minute after we kind of jump in. Or do you want me to go first, Rachel?
No, I can go. Okay. I have been working in higher education exclusively for going on now 18 years. And I started out in student conduct administration and was working at an institution right out of grad school where we had a really punitive student conduct process. So we actually had a strike system at the time. And students often told me that they felt like it didn't matter what they said because they had a really prescribed outcome. And they were right. And it was also a very litigious process, or legalistic, in the sense that about half of my students had attorneys in their meetings with them. So as I was doing this kind of within my day work of addressing violations of institutional policy on a college campus, I was also getting more involved in a restorative justice program through a community-based organization. And to me, it was like a light bulb went off when I looked at the differences in terms of how these two worlds were structured. And over the years, I became more and more involved in investigations with sexual misconduct cases and sexual harassment. And then the two even evolved to be in such a way for me that that interaction and that intersection really became kind of the focus of my work. And now I serve as a Title IX coordinator. I'm at Curry College, which is a small school outside of Boston. And I have had the privilege of working at lots of different types of schools. So now I've been at a big state school, a small private school, at a Jesuit school. And I say that to demonstrate that we're not speaking to something that can only be done on a big campus or can only be done at a tiny college where you might think you don't have the same bureaucracy that you have at a big institution. We're going to talk about ways that campuses can be taking a restorative approach regardless of the type of institution. So that's just a little bit about where I'm coming from. And now I will turn it over to Jay.
Yeah, thank you. So by way of introduction, you know, I'm an attorney and mediator by training, but I spent the better part of 15 years working on campus in various roles, including as Assistant Dean of Students at the University of Utah, and then as Director of the Office of Student Conflict Resolution at the University of Michigan, where I was responsible for, among other things, managing and facilitating their menu of dispute resolution options, including their response to student sexual misconduct. And while there, and I can talk much more about this, was very happy to provide a leadership role to University of Michigan's adoption and implementation of restorative practices for student sexual misconduct, and have been involved with that work ever since. I now operate a specialized law consulting and dispute resolution practice called Klancy Street, which focuses on helping parties find common ground, and I'm still heavily involved in the work of student conflict and student conduct, including restorative justice applications to student sexual misconduct and risk assessment and treatment interventions, among other things. So happy to be with you today. In terms of my journey to this particular topic, though, I want to highlight two things and then transition to talking a little bit about restorative justice. Rachel and I have a few slides planned to provide kind of an orientation and a common set of reflection points for us, but want to spend most of our time engaged in conversation about this and answering questions that have come up, particularly as it relates to the new regulations and their use of the term informal resolution and the like. But to give you a sense of where I'm coming from, I want to begin by letting you know that my journey to this work really began when I was 11. And a very close friend of mine, who was 15 at the time, was on a run and was sexually assaulted by a stranger who jumped out of the bushes and tackled and assaulted her. And fortunately for her, that man was apprehended, was brought to trial, charges were pressed, was sort of arraigned and convicted and found responsible, and was ultimately sentenced to more than 20 years in prison for that offense. So arguably it worked, but there are many ways in which the system did not serve her. It didn't help heal her wounds. It didn't help her overcome various fears made worse by that attack. It didn't help her understand what could have provoked the man to hurt her. It didn't provide any assurance that he would refrain from similar behavior in the future upon his release, either as it relates to other people or with her specifically. The second point of my journey that I want to highlight, and how I come to this work, happened when I was 25. I had just finished my second year of law school and was nearly done with my master's degree in dispute resolution, when I was in a car traveling from LAX to Malibu, and a close family member told me that she had been raped by a friend 2 weeks before. I was the first family member she told. It had taken a while for her to tell me or anybody else, because the first people she told were friends who disbelieved her and told her that she should have known better than to be out drinking with that person. And it was just a horrendous experience, a horrendous response, and everything about it. As her big brother and as a guy who had been trained to serve and answer calls for the Rape Recovery Center, told me that I just wanted to be there and support her and do everything I can in that particular moment. But my 2 years of legal training began churning in my head, thinking, asking all these questions. Have you reported to the police? Did you get a rape kit done? Do we have any other evidence preserved? And going on and on, projecting, because I wanted for her, if she wanted it, the same sort of justice that was available to my friend and our friend years before. I feared, though, that her experience would be worsened by a report and by the eventual talking to the police, and those fears came true in ways that I wish they hadn't. She was not believed. She was asked inappropriate questions about how much she had been drinking and so on. And she ultimately was told that they couldn't do anything about it because it wasn't in her control. So the question that was placed to me and my sister was, what form of justice is available when the traditional form of justice is either unavailable or undesirable for whatever reason? And as you likely know, in a criminal setting, as it was in that case, the victim doesn't make a prosecutorial decision and is not charged with, despite the name, pressing charges. The prosecutor does that. On campus, although the system is a bit better, the new regulations place a burden on the school to investigate. There are still many other reasons that a victim and survivor of sexual violence may not choose to participate, and many reasons why participating, even if it's available, may still be undesirable. So restorative justice, in contrast to the traditional system, aims to localize the process around the parties that are most directly impacted by the behavior and with the person responsible for creating the harm. Unlike the traditional system, restorative justice does not focus on a specific policy violation. It can be done to repair the harm. Another major difference is that it's not offender focused. Restorative justice processes, unlike the traditional system, aren't focused on the offender and his or her or their behavior. It focuses on the victim and the harm caused and what can be done to repair the harm. Another major difference to note up front is that, unlike traditional systems, restorative justice requires the offending party to accept responsibility for the behavior and the harm up front. In doing so, it obviates the need for lengthy and protracted investigative processes. Although the new regulations refer to these processes as informal, it's really important for us to remember that nothing about restorative justice processes is really informal. Circle processes and conference processes, which we can talk more about, are often very scripted, choreographed affairs that involve lengthy planning, especially in the case of student and sexual misconduct, sexual violence, with the parties to prepare them for the proceedings, to make sure we're not subjecting anybody to secondary or re-traumatization or additional harm that could be caused as part of the process. The purpose is to repair the harm, not create new harm. So the circle on this slide really can serve as a symbol for what RJ practices are and what they represent and the way in which they're designed to address harmful behavior. This next slide that I just want to show for a second represents how that gets done. And it involves, for those who aren't familiar, RJ processes involve approaches that involve the harmed party or parties, the person responsible for creating the harm, and the community. These approaches recognize that behavior that violates community norms or standards often harms more than just the direct victim. The community surrounding the harmed party and the responsible party is also impacted. And so restorative justice processes, unlike traditional systems, seek to involve all those parties in the process and make sure that it doesn't happen again and that we're addressing the behavior. The last thing I want to note before Rachel tells us a bit more is that it's important to remember that restorative justice, although increasingly popular now in a way that's positive and good, it's not a new approach. Its principles and practices were developed and practiced by groups indigenous to Canada, the US, and New Zealand, who used it for centuries to address harmful behavior in their communities. It just so happens that we're beginning to realize the utility of some of those processes now, and particularly as it relates to sexual misconduct, which presents several unique and complicating features to the application of restorative justice principles and practices. So with that orientation, Rachel, I think wants to talk a little bit about how it applies to kind of campus sexual misconduct and gender-based violence in particular.
Thank you. So I think when we hear that and we think about the role of community on campus, sometimes what we express concern about when we think about empowering someone who identifies as a harmed party to dictate or be actively involved in what we do about that, and to actively involve the person who caused the harm. What about the community? So sometimes people raise concerns about how it is that we prioritize the needs and the safety of our communities as well. And so I think it's really critical to also emphasize that this is not a process that lacks accountability. This process is centered around accountability, and on college campuses, it's not to suggest that it's an alternative to separation. There is a place for these processes, and we'll talk more about what they can look like in conjunction with traditional criminal systems and adjudication systems on college campuses. So when we put up that slide of the contrast between the two, between a legalistic framework or retributive justice framework and what we mean by a restorative framework, right there, thank you. Part of what we are really doing is also to draw a parallel with college campuses, because it is common that we focus on what law was broken in our criminal process, and on our college campuses, it's common that we're really focused on what policy was violated. And with Title IX regulations, it does cause us to need to be attuned to whether or not the behavior is also a violation of Title IX and of law. So we don't have the ability to put that aside, nor should we not have rules on our campuses. It's okay to have community expectations. But what happens when it comes to gender-based violence is that when we take an approach that is really focused on a policy violation and our institutional obligation to be neutral, which is real and important, and people have an opportunity are entitled to a fair process and a due process within public institutions. But when we fail to center the harm and in the way that restorative justice does, we do exactly what Jay was speaking about in terms of inserting skepticism at best and at worst an assumption that someone is lying and that the information that they're providing is not accurate. And we know that that's a reason that gender-based violence on college campuses is incredibly underreported. So a piece of that is that what Jay described as potentially undesirable options prevent people from feeling like they could come forward. And we also know that there are a lot of students on campus who engage in harmful behavior and either know that that's the case or upon finding out, and certainly my experience, and I'm sure Jay's in working with lots of students who have been responsible for causing harm, is that that can be really devastating to them too. And so we are talking here about the idea that we would center the harm and center the opportunity to repair it, and that lives both with the person who is responsible and the community, that we have a role as a community and as college campuses to be a part of that solution, because the process itself is part of what contributes not only to underreporting, but to the prevalence of sexual violence to begin with. So we know that our systems are not always designed to help prevent this behavior, and that they're certainly not responding in a way that meets the needs of everyone. So I spoke to it being underreported, incredibly prevalent on our college campuses, that we often have these sort of legalistic institutional policies. We also know that that can have a disparate impact on members of our institution based on identity and privilege. And so those who may feel that they can report and those who can't, or those who worry that being identified as someone who engages in this behavior may look very different for one student than it might for another based on aspects of their identity. So that piece of intersectionality, I think, is really relevant when we talk about restorative justice and the value of having restorative approaches available. So we're talking both about creating ways in which people can be held accountable, can accept responsibility, and also give voice to those who have been harmed and those who are responsible in ways that in other systems they may not have a voice at all. So you can go ahead to the next one if you want. So when we talk about a restorative approach, there are a few kind of key principles here, because there really is no singular definition of restorative justice. It's a framework, and a restorative approach is one in which we prioritize relationships over rules, that we're really looking at an offense as harm against a person, not just a violation of a school's policy or breaking a law. They also are processes that address needs and harm and recognize that those needs that are there for someone result in an obligation by someone else to address that harm. And so that doesn't always have to mean bringing parties together. We're going to talk momentarily about some different ways in which you can apply a restorative approach, but just speaking broadly in terms of what that framework looks like, it starts by centering those principles. They are collaborative in nature, so they're including and engaging stakeholders. A restorative process or a conference or a circle would utilize a neutral facilitator. So like Jay said, it would be a very choreographed and kind of planned, highly planned process that utilizes a neutral facilitator, so that individual doesn't determine the outcome. The parties directly involved determine the outcome. But what differs it from something like mediation, that people sometimes throw those terms around under this umbrella of informal resolution as though they're one and the same, is that there is one, if not more than one, individual accepting responsibility for causing harm, and people are clearly identified as harmed parties, as community members, as support people. So someone might not have to enter into, ideally they would not enter into any kind of dialogue without having support systems, regardless of their role within that restorative process. And the last piece that I just want to emphasize is that these processes have equal concern for responsible and harmed parties. Restorative justice starts with, in the sense that it is victim-centered. It starts with someone who has experienced harm, even wanting this to be something that they would consider, but it also requires that the person who has caused the harm is also open and willing and voluntarily participating in a restorative process, and that we can equally honor the humanity of the people involved without condoning the behavior. So we really are separating, when you think about students, the student from the behavior, which can be hard to think about, I think, for those who don't always use this lens. But I think when we work with survivors all the time, they care about that individual if they knew them. They may care even if they didn't know them, in the sense that they don't want this to happen to someone else, or they want them to truly understand the impact that it had on them. So those various needs that we hear from survivors who go through these processes link back to a level of care, not necessarily about, but for the individual who may be responsible for causing the harm. So it really does require that equal concern for all of those involved. And now, do you want to kick off a bit about some of the potential opportunities to apply a restorative approach?
Sure. So, one of the things that can be difficult to imagine when talking about restorative justice is exactly the way in which it will operate and the number of options, because restorative justice, I like to think about it, refers to a set of principles and practices. So it's not, as Rachel said, a single approach or a single practice. So when we talk about the potential opportunities and benefits, we're talking about how restorative justice can be applied at various stages of a process for different purposes. So as an example, it might be applied in a conferencing process, conferencing form, to resolve and address the foundational complaint. So following a formal complaint being filed, if a institution makes it possible and available, an RJ conference process could be utilized to permit the responsible party to accept responsibility for the behavior and the harm, and to engage in a process by which they seek to repair that harm, and then to develop a set of a package of interventions or sanctions in the form of a resolution agreement that would be followed and could be integrated to address the harm. It could also be applied, for example, post-separation from the institution, after a period of suspension, in a way that models a restorative process called circles of support and accountability, that has demonstrated efficacy in reducing the recidivism rate for individuals with problematic sexual behavior. And what that process does is, in a very restorative way, seek to, as Rachel said, recognize the humanity of the responsible person, recognize that the environment that surrounds that person can have can contribute to further sexual violence, or mitigate against it in a protective fashion. And that one of the features that contributes to sexual violence is social isolation, the inability to get housing or employment. And through a circle of support and accountability, we may be able to, or can rather, reduce the likelihood and further integrate that person back into the community. So those are two ways. I can think of others too, Rachel, but if you want to.
The only other one that I would say is that I often talk about the concept of restorative discipline. So this doesn't include a complete separation between an institution's ability to make a decision. So it's the idea that you aren't necessarily strictly giving decision-making ability to the parties involved. But if you're engaging in restorative discipline, you can still center the needs. You can listen for what it is that a reporting party or someone who identifies as a survivor potentially wants and needs through a process. And you can, to the best of your ability, create space for those who do feel responsible for causing harm to do so, to indicate that that is in fact how they feel, because we structure our systems sometimes so that they can be so shaming that if someone did want to acknowledge that they caused harm, the stakes may be so high that there's no incentive for them to do so. So through restorative discipline, we can challenge ourselves to think about, how do we create systems in which people who do feel responsible have a space in which they can do so. And I often say that offering these options is an alternative to doing nothing. So we get nervous that we need to stick with our litigious mind frame, or just our retributive justice system where we're punishment focused. And unfortunately, if that's not an attractive option for someone who's coming forward who's been harmed, they often will do nothing instead. So what does that do for them? What does that do for the community? What does that do for the person who engaged in the behavior to learn how to not do it again? So it's really critical that we have a wide range of options. Bringing parties together or creating space for someone to accept responsibility is not going to be appropriate in every circumstance, because there are individuals, first of all, who are not responsible for causing harm, and second of all, those who may have caused harm and are never going to indicate as such. So it's really important that we recognize that we're not saying this is a one-size-fits-all approach, but that it is a tool to have in your toolbox to be able to better serve students and communities.
So, a couple pieces to note. One more thing I'd like to say about benefits, and then talk a little bit about where we go and before we turn it over to questions and open it up. But in terms of benefits, I think it is critical to highlight that when we talk about restorative justice applications or restorative justice as applied to gender-based violence and sexual misconduct, we're not suggesting that it be the default or the only choice, right? This is and will always be an option for those who want it. So those students who see the utility in an approach like this, who view it as being more responsive to their victim, to the needs of the victim or the survivor, the complainant at issue, and for the responsible person who is willing to accept responsibility. I often say that I am in favor of processes that encourage truth-telling. And as Rachel said, so much of the traditional system disincentivizes truth-telling. It encourages positionality, adversarial approaches, silence in the face of knowing that we or the respondent have done something wrong. And so by creating restorative approaches, we seek to open the door to accepting responsibility and acknowledging that that we as people are capable of harming each other, and that it is our job to do that in a realm of sexual violence. Of course, that harm is incredibly difficult to repair and may not get done through the course of just a restorative approach alone. But we seek to begin that journey through the process itself, as Rachel mentioned. So in terms of where this goes and what can be done on your campuses, it's really important to recognize that restorative justice and the interest in it is really a global movement. And there are folks who have been working in the field of restorative justice for decades, who have integrated these approaches into high school settings, into the post-secondary settings, and community-based settings. And we have come over the last 6 to 10 years to perceive the utility, perhaps a bit longer, perceive the utility in addressing complaints involving sexual violence and gender-based violence. If this is something that you are really interested in, either personally or for use on your campus, it's really important to identify allies on your campus and beyond that can explore this and figure out how would this work, especially given the permission that has been granted through the new regulations to utilize restorative approaches. How can that be done? There are resources out there that exist, and Rachel and I can direct you to some of them. There's training that you can participate in. This is one example of something that you can participate in to open your eyes to what's available. It's possible to bring trainers or facilitators to your campus and have them speak about restorative justice approaches. In so doing, it is critical to challenge underlying assumptions about what RJ is and what it's not. So a lot of times we find when talking about restorative justice that people hear light on accountability. And I'm here to underscore that that couldn't be further from the truth. Restorative justice is interested in a full, effective accountability, up to and including what could be a permanent separation from the campus. So some people say, Jay, a person will never accept responsibility for problematic sexual behavior, or if they do, it would only be for sexual harassment. It wouldn't be for forcible penetration or rape. I can tell you that's just not true. I've done it. I've had students accept responsibility for this behavior and who are bravely willing to acknowledge the harm that they've caused and take responsibility. So it is neither light nor is it a preordained fact that no responsible parties will ever participate in this for fear of the consequences. That's just not true. And so we are still sort of on the leading edge of this journey, especially as it relates to the new regulations and folks getting familiar with it. And so there's a great deal more we could talk about and hopefully have time for. So I'll leave it at there. Rachel, if you want to follow up with or add their resources.
Sure. So in addition to opportunities to identify partners on campus who you may not even know already have an area of expertise, I am fortunate on my campus that I have a faculty member who has been doing this work well before I was on the campus. I was doing the work out in Colorado, and she's been doing it in prisons within Massachusetts and working with individuals who have been convicted of murder to facilitate restorative justice processes in the prisons. So to have arrived on a campus where there was some familiarity with that language of what we even meant by restorative justice was great for me when I then wanted to say, we can actually be using that here as well. It will look different. Here's what it's going to look like for us. And so for several years, we've been conducting training to get folks on board, and ways in which you can also seek out additional information include finding campus-based training opportunities and community-based training opportunities. So Campus Prism is one that we call out that specifically focuses on sexual misconduct and the application of restorative practices. Community-based programs may be available to you near your campus where you could go get trained there, or you could potentially bring them to your campus to facilitate some training for you all as well. The International Institute for Restorative Practices is up there, which has tons of resources that you can access online and participate in training through them as well. And then the National Association of Community and Restorative Justice has an annual conference and has resources you can find on their website as well. So those are just a few, but I feel confident that both of us would absolutely love to continue a conversation with those who want to explore more and better understand what's available out there. I also feel like there's space for schools to be utilizing external facilitators in ways that don't take away an institution's ability to speak to what an outcome could look like, but to actually be an active participant and help create an agreement where it meets the needs of the harmed party, the responsible party, and the campus. And so I think both of us are excited to see that campuses are increasingly looking to use these practices and both train folks internally and potentially access some of these resources up here to seek external training as well. So at this point, I know that there are questions. I've seen some of them pop up, and we're excited to have some conversation with you. So I don't know if it makes the most sense to turn it over to Sylvia to share with us what some of those questions have been, and we can certainly pull up the chat as well.
Yeah. First off, I just want to say thank you so much to both of you for this information. I know that we've had a lot of students not feel that they identify with the options that we have right now. So this is a really important conversation for all of us to have. Thank you to both of you for the work that you are doing and have done in this area. And we have had a couple of questions come in. So I can go through those right now, and then if either or both of you want to answer, please feel free to hop in. All right, so we have a question. How do you make it safe for an offender to take responsibility and admit the behavior and harm they caused as part of a restorative process without that becoming a risk to themselves if there is or could be in the future concurrent criminal processes?
So the first thing that I would add, and then Jay can certainly jump in as well, is to know your state laws with respect to if something has been reported to law enforcement. So in Massachusetts, we're fortunate that based on recent criminal justice reform, we now extend confidentiality to restorative justice cases, but only those that have been referred by a police department or a DA's office, for example. So on campus, in campus proceedings, we have to be incredibly transparent about where that information can go and where we cannot control that it may go. And I do think that it's really important that institutions write into their policies how that information that may be used within a restorative process can or cannot be used in a traditional adjudication process or an investigation, a Title IX hearing, for example. So as every school has had to rewrite their policies based on the new Title IX regulations, as you're rewriting them on your campuses or those you work with are rewriting them, to be mindful of that and to be transparent about what information can and can't be used and what records are maintained when individuals participate. So there are some things you can do to make people feel more comfortable participating. At the same time, if you can't guarantee that something may not be subpoenaed, for example, then you want to be clear about that. And I always say, that is not different than what may happen if someone participates in a traditional process. So people are often very open throughout an investigation. I think in the great majority of cases, in my experience, the facts of what transpired are often not the detail that's in dispute. It really comes often to someone's perception about whether or not an experience was consensual. And so when we create spaces in which people can hear that someone did not feel that it was, whether or not that was their intent or they knew, which again may not make it an appropriate approach in every sexual misconduct case. If, for example, something was intentional, knowingly harmful, it may not be that that individual is appropriate to either accept responsibility or to not re-victimize, which I know was another question that came up, and we can talk more about that in a minute. Do you want to add to that, Jay?
It's a great question, and it's certainly a central concern of a process that invites someone to take responsibility. And I see one of the follow-up question is, particularly as it relates to potential criminal responsibility if someone accepts responsibility. And so I think Rachel's right on that it is a key feature of program development to understand the unique features of the applicable state law to understand how this process will be treated in terms of confidentiality and potential future disclosure to investigators outside the university or to a prosecutor. One thing that I might just mention as an addition is that some RJ programs for sexual violence have also been developed in close cooperation with local prosecutors and DAs to develop essentially agreements not to prosecute for violations that or matters rather that are routed through a particular program. That particular DA or prosecutor may choose to limit their willingness to do that to a particular subset of behavior on the continuum of sexually problematic behavior, or permit the program to to address all forms of gender-based violence. So it really depends, but I think Rachel's hit the nail on the head in terms of the possibilities and the importance of designing the program around your unique state law.
And I guess I will add to that as well that you need to be transparent about whether individuals who identify as the harmed party are waiving their right to anything. So if they are going through this process, does that in some way then preclude them from proceeding with another process? And if so, at what point throughout this process can anyone back out or pursue your traditional grievance procedures, so to speak? I will also say, piggybacking on what Jay said about partnering with law enforcement, that I have brought together individuals involved in sexual misconduct where the police department did not have sufficient evidence to know that it was going to go forward. So there may be, to Jay's point, it may not be that they are necessarily getting a verification from the criminal justice system that this won't go forward, that someone has said we will not prosecute, but rather that the parties know based on the information that is available that it is quote unquote not a good case, that it may not be successful in going forward criminally, or the police have already said, for example, we don't have enough for an arrest or an arraignment. And so those are cases in which we see that it can be an attractive option to be able to offer something else to these parties if it's of interest, if they're willing.
Thank you both. And sort of going off of that question, we have a follow-up question. Are there any cases that you could recommend for people to look at as examples in the campus space?
I think there are, and Jay has been involved in the development of some sort of templates and different examples of how it can be done, and sort of scenarios that certainly we can follow up with individuals who might want more information about kind of case studies. In terms of specific examples, I think the confidentiality makes it such that it's really upon an individual, and it would really have to be both individuals, as far as I'm concerned, who would be willing to put their story out there in such a way that it is identifiable. Otherwise, I think there certainly are examples that we can speak to. I have many that are anonymous and that are not documented, so to speak, but are cases in which we both have been involved that we could speak to how they unfolded, but not, I don't have any that I could provide as written examples.
I will, I'm going to find it here and place it in the chat box, but there is a great, well, I should say that I first became aware of it probably 5 years ago, a matter arising out of the University of Puget Sound, where a harmed party and the responsible party created ad hoc a restorative process to address the matter between them. And one of the features of that process had the responsible party not only accept responsibility in public, but accept responsibility publicly in the student newspaper. And when I first saw it, I was just floored at the power of it and the willingness of this responsible person to accept responsibility in such a public fashion. And that story has since resulted in a podcast that is also wonderful. So I will find it. I'm just looking at my files here, but I'll find it and put it in the chat before, so you have a link to that story and can follow up in a way that is out there in the public.
I have that as well, the write-up, the student newspaper, but not the podcast. So that's great. Thank you.
Amazing. Thank you both. And as you look for that link for the chat, I can ask you another question. We have quite a few. A few folks are wondering if there are certain areas of gender-based violence that you would or would not recommend for restorative practices.
I mean, off the bat, I would say that what makes a situation appropriate for restorative justice is not always or necessarily the nature of the offense to begin with. It's really the way in which the parties involved are coming at it. And I say that because it can even be used within the prison system, where we may have a situation in which someone has been convicted and incarceration is appropriate, and the parties may wish to participate in some sort of restorative process. Often, to prevent re-victimization, which I know is a question that someone posed, or to minimize that likelihood, those processes will use surrogate victims and surrogate offenders, which means that someone might be sitting down with a different individual who has been impacted by or engaged in that behavior, as opposed to the one that they had their experience with. It doesn't mean that it can't be done. I would venture to say in most for most types of offenses, if the circumstances are appropriate. I would say I would be extremely hesitant to use it in situations such as stalking cases, situations that might involve a stranger assault. I mean, first and foremost, the safety of the parties is the priority. And so it is not appropriate in circumstances in which it is unsafe to bring the parties together, whether the offense was incredibly violent and egregious or not. It could be that there is a harassment case that is not appropriate to bring the parties together because of the risk of re-victimization. And you could have a sexual assault case that, based on the nature of the relationship between the parties or the accountability being demonstrated or responsibility by the individual responsible, that you would bring them together. So it isn't determined as much by the offense itself as the circumstances surrounding that offense. Do you want to add anything else to that, Jay?
I just echo that I hesitate in I'm not an advocate for creating particular cutoffs in terms of the subtypes of behavior or the types of behavior that are or are not eligible for restorative justice approaches. As Rachel mentioned, these approaches have been used very successfully and with a high degree of satisfaction for victims and families, even in murder cases. And they have been used similarly in sexual violence cases of all types. And so I'm just very reluctant to create a subset of behavior that is only eligible. Having said that, I know a lot of people do it. And I think such an approach could make a great deal of sense in a graduated implementation process that seeks to sort of get the campuses ready for permitting a restorative justice approach in all matters by first getting restorative justice approach right in matters that are less severe or perhaps less consequential. I even hesitate using the term less severe because we know that a victim of sexual harassment can have profound impacts even in matters that doesn't involve any physical contact. And so I don't like that particular bifurcation either, but that is to say that the campus may, I think, with good reason, find themselves willing to implement it for a specific subset of behaviors pending development, evolution, and growing confidence among administrators and the community in the institution's ability to carry out the process.
I also think to honor the apprehension that victims will be forced into informal resolution, which is, I think, a legitimate concern that we sometimes hear. This process needs to be voluntary, and we need to acknowledge that the great majority of students that I work with anyway, and that I think experience sexual misconduct, this is not the process that they want. And that's because many of them are not pursuing any process at all, any reporting process. And maybe what they need is a different level of support and healing from a mental health provider or the support of friends or family. And so while we, I think, on college campuses and in communities always want to hold people accountable when they cause harm, we also recognize that we can't prioritize that outside of health and safety emergencies where we need to proceed against a victim's wishes, that we may have many, many students for whom this is not what they want either, and that's okay. And we have to acknowledge that. That this, again, like we said earlier, is not to suggest that this is the right process in every situation, because it won't meet the needs of everyone. And I also have students who this is absolutely what they want, and the individual who harmed them is not accepting of responsibility. And so it's not an option that's on the table, because even though it's what they wish it would look like, they have not had that acceptance of responsibility shared with them or with us in a way that we would feel comfortable moving forward.
Thank you for that. And sort of going into how a campus would be able to put this into place and how to move on that, we have a good question. Can RJ work within the current Title IX provisions of informal resolution? And I leave it to you to figure out if current means as in right now or as in next Friday. So
I'm gonna guess that it means next Friday. All eyes are on next Friday. Absolutely, institutions can build in informal resolution processes under the new regulations. There are nuances that schools have to be attuned to when the alleged behavior does constitute a violation, or would if it occurred, of Title IX, in the sense that schools are still required to receive a formal complaint from a student. It is an option in instances in which the school receives a formal complaint. So really separating out our understanding of formal complaint versus formal grievance process versus informal resolution. So there's a lot for schools to unpack to ensure that we're all complying with the regulations. But ultimately, there absolutely is space for restorative processes, I believe, both when a situation falls within or conduct falls beneath Title IX and outside of it, because we've also heard over and over that these regulations do not preclude an institution from addressing behavior that does not constitute a violation of Title IX as articulated as of next Friday. So I think that's also really great for schools to be bearing in mind, that there will be lots of other behaviors that fall outside of this scope. There already are, and that we can be thinking about how to use restorative justice approaches in both, whether it falls under your Title IX policy or within whatever other policies you might be using.
I would just say that, you know, the new regulations definitely specifically authorize the use of restorative justice practices, and so we will see them more broadly utilized. The important part is to distinguish, and we mentioned this briefly, but it's worth emphasizing, the difference between restorative justice processes, which can be, when tailored appropriately, very useful in addressing sexual violence, with mediation, which as a process is not traditionally and typically designed to do this. And a distinguishing feature between the two is that most often mediations presume sort of equal footing, although they don't presume equal power, or they do start off with the premise that we have a conflict that needs to be resolved. And restorative justice, as Rachel mentioned earlier, doesn't begin with that premise. It begins with the premise that we have a harmed party and a person responsible for that harm. And in so doing, we're not approaching it like this. We have a potential for criminal conviction for some types of behavior, and we need to repair the harm. And so we could have a whole different session about the difference between RJ and mediation and concerns we might get. For now, I will let you know that I'm going to place in the chat box a comment that I drafted and we submitted on behalf of Campus Prism as it relates to these new regulations, which I think remains relevant in terms of the way we talk about it, and cautionary notes about how we refer to it as informal when it's not, important distinctions between RJ and mediation, and the like. Recognize, please, if you read it, that it was written prior to these regulations as an attempt to sort of influence it. But I think you may find useful terminology and language in there.
Thank you for that. Thank you for anyone who didn't see, the podcast was also pasted in the chat. So thank you for that. We have going more into specifics, we have a good question here from Jordan. I work at an institution that is looking into bringing RJ as an option for students. Would you recommend the university hire a separate staff member and create its own small office specific to RJ? In parentheses, separate from disciplinary office and the office that supports students.
I think that it will really depend on what meets the needs of an institution. Anyone who is in a position financially to be able to bring in an additional person to do this work, I say go for it. It requires a lot of time, so I think it is critical that there's a recognition of that and a designation of individuals to be responsible. It does not need to be a separate individual, so I truly believe that it can become embedded within the fabric of an institution, and that, for example, a Title IX office or a student conduct office, or however an institution is structured, can embrace and utilize restorative practices and use restorative conferencing. So I think both of us, because Jay and I have had this conversation a number of times, don't believe that it needs to be separate, in the sense that it could be an option within your overarching policies and processes. At the same time, beyond its use for sexual misconduct, there's such great opportunity for institutions to use it both for prevention and community building, if individuals are empowered to be able to do that, whether hired or trained within, and to address a wide range of conflicts and incidents that occur on college campuses. So I would never discourage someone from wanting to create positions that can focus on this work, but I also don't want to suggest that it has to be done separately, because I think it absolutely can and is being done integrated on other campuses as well.
I don't really have anything to add. Just would second that I think how you do this will depend, and as a matter of sort of systems design and programmatic design, I can see answers that are right in both ways. The important piece is, as with investigations, which will continue to take place, that this be done well, that we not see the permission granted in the regulations as the existence of capacity immediately. So just because something is permissible doesn't mean we should do it. And that is a part that's emphasized in the comment that I put in there, that let's not forget that specialized training, as with almost all things involving sexual violence, is critical. So if it exists on your campus, great. If it doesn't exist on your campus, don't go about diving in without the
and
training.
to know that you could build it in and identify individuals who are qualified to be able to do that, based on identifying community-based programs or other campus partners, or developing that capacity. But absolutely, I'm with you that it's not there just because the permission has been granted, but that you can structure your process in such a way that it would create space. As I think the analogy to investigations is a good one. There could be a case in which someone is conflicted on a campus and needs to look to an external investigator, for example. And similarly, I think that schools can be looking at how do we partner to address these cases using those who are qualified to do so.
Thank you both. And speaking of partnering, as this practice grows and as more of us are aware of what we can do in regards to restorative or alternative options, and that it is becoming more and more clear that not all of us have the same sort of healing journey, what are some ways, because I've seen some questions, that people can continue to connect with others doing this work and create their own community so that they stay informed as we create and develop best practices in RJ.
I'll just say that there are both the national resources and networks that we put out on the resource link, and that on our campus, we have found it really powerful, and I have no doubt that Michigan did the same thing, which is to create spaces in which students, faculty, and staff are trained together, which is so rare, I think, on college campuses. And so we've had the privilege of hosting a number of trainings where we were able to get those who may identify as survivors, students, faculty, or staff falling into that category, to also be a part of bringing restorative justice to our campus. And there are many opportunities regionally, institutionally, internationally. I mean, as Jay said, this is something that is being used around the world, and we are largely drawing from the wisdom of those who have been doing it far before it is now being embedded into our traditional systems. So there really, I think, is great momentum and opportunity to connect with others who want to see us doing this as well. We had a bullet we never spoke to on one of the slides that said something you can do is to challenge assumptions. One of the ways I think that people can do that is to hear things like, that student's still on campus, so nothing happened. Well, that could be that that individual went through a restorative process. And how do we know that? We need to start by training our campus communities on how we address this type of behavior, so that we're really challenging not only our own assumptions, but other people's about what accountability looks like, and challenging sort of our expulsion and cancel culture, that if someone engages in this behavior, you know, and this is not to suggest that there are not people who could lose their right to be a member of our communities, because there are and there should be. And we need to recognize that, where does community begin and end? So if, for example, we suspend a student, are they then transferring to someone else's campus, or are they living a block from campus, not enrolled anywhere? So the idea that we look differently at what it means to be in community and to hold people accountable, I think, is a piece of what we're talking about as well.
One piece I might mention, Sylvia, one question: are we scheduled till 1:30 or 1? I had us till 1, but I'm wondering what the participants are wondering.
We can go until 1:30. It won't kick us out until then. So if you have other comments, questions, anything helpful, go for it.
Well, the piece I wanted to mention is that, you know, I think it's important to recognize that the development of an RJ process on your campus, as it pertains to any type of misconduct or sexual misconduct, is iterative. You will not land in this ideal place in one fell swoop. Having worked my tail off at the University of Michigan to create space in the policy that would allow for a restorative approach and the support among key stakeholders, I can tell you that our first attempt at that landed nowhere near where I was hoping we would land. Where we were successful was in creating a what I would describe as a restorative based sanctioning process, that essentially, once a finding had been issued and there was a determination of responsibility, it then allowed a responsible party to accept responsibility further at that stage, and to voluntarily engage in a sanctioning process by which they would work with the community or a community representative and the complainant to develop a package of sanctions that made sense in addressing the specific harm in that case. That's different than the conferencing process that we described earlier, and it's just what was possible at that time. And so I'm very glad that that work has continued to expand, but it has taken years to do so. And it's important to recognize that you begin by starting with these conversations on campus and reimagining what's possible and how this could work, and what would this mean if we did that, and then developing the capacity to actually make it happen.
Yeah, thank you. We actually had another question come in. How do you ensure student survivors do not feel pressured or coerced into an RJ program? We've talked about this a little bit, but if you could expand on that, that would be really helpful.
It's an enormous responsibility. I will just start by saying that whomever is tasked, and often with the way that we're structuring our Title IX processes now, that discretion lies with the Title IX coordinator in terms of when an informal resolution. I think often institutions may write it as it is within the university or the college's discretion to determine when it's appropriate, first and foremost. And that means that they need to be sensitive to when it's appropriate to begin with. Second of all, ensuring that individuals are not being pressured into doing it means that we are getting voluntary written participation from individuals, that they are bringing support people with them who can also help be a sounding board and ensure that it's what they actually want to see happen. A trained facilitator does not determine the outcome. The parties determine the outcome. And I can say that there have been times where I have seen both those identifying as harmed and the responsible party not getting their voice in the room. And that is the role of the facilitator, to say that you don't have an agreement until you know that it is meeting the needs of all of those parties. And so I've seen individuals who have been harmed feeling that they are not getting their needs met, and that's where the facilitator needs to address that. But similarly, I've seen cases in which a responsible party just shuts down. And if they don't have agency and an active role in agreeing to items as well, we're not as likely to see completion. We want to see buy-in and voice from everyone, from both the harmed, responsible, and the community, because I think, again, there is a need to be thinking about risk of harm to the community. That is not the responsibility of the individual who has been harmed to be worrying about whether or not this is going to happen to someone else. It is the responsibility of an institution to care about whether we're taking reasonable and appropriate steps to minimize the likelihood that it will happen to someone else. So I think it is all across the board. That's where we talk about the importance of having a highly trained facilitator to ensure that no one is being pressured into either setting foot into this kind of process to begin with, or reaching a resolution and walking out the door. That's why there needs to be assessment of whether the parties feel that it truly was voluntary. Jay spoke to some of the satisfaction data that's out there and how it compares to those who go through traditional systems. So I think it's important that we as a field continue to do all of that. That is the integrity of the field, really, to ensure that it truly is voluntary.
And I would add, and then I see another question that that is asked that we can address, that I think it's critical to understand and think about how the design of our programs and the wording in our policies can be that arm twisting that we seek to avoid. So arm twisting and pressure can happen through a staff member who is inappropriately directing someone toward a process, but it can also happen as a matter of policy. And I can tell you one of the features of and this was a question that I saw, one of the features of the regulations is that it requires a formal complaint to be filed in order for an institution to offer an informal process. It's a bit of an arm twist as a matter of policy, because it may force a complainant to do something they don't want to do in order to access the process that they would like to have access to. And that's unfortunate, but that's the way it is at the moment. What I would offer in that context is that RJ processes do not exist solely at an institution. And so they are not wholly bound by those the features of Title IX regulations and protocol. It's certainly possible for folks to seek out a community-based practitioner if one exists in your area to facilitate such a process completely separate from the campus. So it's possible conceptually. How often it happens or not, I have no idea, because it would be so difficult to get data on it, but it's possible. The other piece that I just wanted to mention, because I've seen it come up, is would an RJ process result in somebody being placed on the sex offender registry? And the short answer to that is no, because it's not a criminal process. Just as though a finding of responsibility at an institution does not result in an individual being placed on a sex offender registry, neither does an RJ process. That is a feature of a criminal proceeding, and as a national database that is facilitated by parties outside this arena. It is certainly possible, though, to create some feature of a resolution agreement that has some similar effect if what you're hoping to do is protect other people. But we'd have to have a whole conversation about the purpose of the sex offender registry and how, if at all, it is effective in managing or reducing the risk of reoffense. I can tell you there's some data out there that indicates that it actually could increase the risk of reoffense by the way in which it further isolates. So a separate conversation, but no, it doesn't put them on the registry is the short answer.
All right, thank you both. I had a question come. If anyone else has other questions, please feel free to put them in the chat. I did have one come in privately, which I think is a really great question that I want to ask you. But it is, can you talk a little bit about how the field has been shifting towards restorative justice? There has been a move to acknowledge failing or existing criminal legal systems that we have, and how can RJ play into that? And yep, that's a good summary of it, I think. Do you have any thoughts on that?
I love that question, because it is so exciting that not just institutions, but that in society, that in our country, that we're looking at how we fund the systems that are in place to address these incidents. And obviously, one of the things that people are talking about is reallocating funding from police departments. And I will caution that it's really important before we do that to look at where restorative justice programs are receiving their funding, because in my region, it is through the police departments. So we need to have really intentional conversations about how we bring additional funds to those doing this work, and not exclusively through our police departments, but we have partner police departments across Massachusetts who are contributing to the work that we're doing. So I think it's a great question. My sense in terms of how we see it shifting, like Jay has said, I think there is a significant amount of increased interest, and in part it is because people felt concerned or conflicted or deterred from using informal resolution previously on college campuses for sexual violence. And I think a piece of that was this conflating of mediation and restorative justice, which frankly is still there under the new regulations. And I would like to hope that now that people are learning to better understand that distinction, that they recognize that there's a real place and opportunity for restorative justice within addressing these incidents on campuses.
I don't really have anything to add to that one.
I should have asked.
Okay, great. Well, I think that, okay, we'll do one more question. We have a couple minutes left, so if that's okay. and then we will close out. So from Dawn, do the police receive trauma-informed training in regards to restorative justice?
So the police departments that I work with are required to undergo training to be able to participate in these processes. The extent to which each of them receives trauma-informed training, I couldn't speak to. I know that on college campuses that I have been involved in, they specifically are, or certain officers are trained to respond, for example, as sexual assault trained officers who might receive additional trauma-informed training, response training. But whomever is involved in your process needs to be trained. And law enforcement is a perfect example of that. And going into new processes regularly where I'm getting the opportunity to interact with a variety of police officers who are coming to this work to see the power of a well-trained or a police officer who buys into the work that we do is just incredible, and really has the opportunity, I think, to completely shape, both to give a sense of safety to someone who has been harmed by participating, and also to really empower and support someone who's responsible to go on and make different choices. So I definitely think not only is there a space for police departments, Jay and I have had some conversation about belief that we really need to be at a place where restorative justice is separate from our criminal justice system, in the sense that it is not truly restorative if you are knowing that if you don't satisfactorily complete your agreement, for example, it's going to get referred back to the police department. My feeling is, to his point of it being iterative, that we have to start by examining and altering our existing processes, and that includes involving police departments, involving DA's offices and courts who are referring these cases around the country. And so I think I see that as a positive, that we get that buy-in as opposed to operating separately. And I think there is still a place for our traditional systems in cases in which this is not appropriate.
Yeah.
All right. Oh, sorry, go ahead.
I was just going to say, I think, you know, I'm so appreciative of everybody participating. And I think, you know, our desire for something better that addresses these issues more fully is nothing new. I can think of, you know, this great, they called it the Pound Conference, but it's held in 1976, called a Conference on the Popular Causes of Dissatisfaction with the Administration of Justice. And it involved lawyers, judges, police officers, all sorts of people involved on the civil and criminal side, expressing what wasn't working about the traditional systems. And we have been fortunate over the last almost 10 years to be actively engaged in that conversation about how this can get done and be done most effectively on our college campuses as it relates to sexual misconduct. And this is clearly one part of the conversation and one part on the journey that we're all just about to enter into a new phase of it. And it will be really important for us to have ongoing conversations with our partners in the police department, our partners in local prosecutors' offices, our partners all over campus on how we go about the complex work involved in providing justice to those who have been subjected to sexual and gender-based violence. And this is one component of it that I hope you have gotten the picture that can be useful for as an option for some people on campuses, and look forward to being part of that conversation moving forward.
Well, thank you both so much. We are almost out of time, so I do want to make sure to wrap up, but I wanted to say thank you both for all of everything that you've taught us today. I think that we're going to have a lot of follow-up questions, so look out for those. If anyone wants to view this recording, it will be on our website at the bit.ly. It's bit.ly/Summit Series 20. Summit Series is in all caps. So feel free to check back there. We are getting a lot of thank yous in the chat. I think that you're right that the field is moving towards RJ in a really beautiful way. And as we go on this journey and we refocus, as we should, on addressing harm caused as a community, I think we're going to see really great things come. So I do want to say thank you. Do either of you, and then Jay shared some contact info. Feel free to reach out. Do either of you have any closing words? I can't say thank you enough.
No, I'm so thrilled that this many people want to talk about this topic and that there is such interest and momentum, and we're just grateful to you and to End Rape on Campus also, and it's on us for creating space for us to have this conversation, so thank you.
Yeah, thank you.
Yeah, thank you both so much. I think that's what we're all here for, right? Creating space, especially at a really tough time right now with both the public health pandemic and the racial pandemic happening right now. But thank you all. Catch the recording on the website and have a lovely Tuesday.
Thank you so much.
All right, bye-bye.